Hello, hello everybody. Having a lawyer to answer questions is not a good idea to start with. So, following the old tradition, century-old tradition of my profession, I'm not going to answer any question, but I am going to give you some comfort, and hopefully you're not going to be charged for that. I will tell you a few things about the landscape right now in terms of reuse of public sector information, which is a cornerstone in all your work. You need to have access to this information, and you need to be able to share it and reuse it in multiple ways in order to achieve your research or commercial results, and more frequently than not, as it appears today, both. So a main instrument for doing that is the directive on the reuse of public sector information, which came in 2013, 10 years after the previous directive, to actually try to harmonize national legislation with regards to the reuse of public sector information. And we'll see what this elusive term means later. We're also going to see that this is important both from the perspective of the reusers of information, but also for the perspective of the producers of information, which more frequently than not, they actually tend to be the same. This is because you always want to have data to reuse in order to produce different models or services, and at the same time you want to know how you're going to release your own data, especially when you are a public sector body. So the PSI has as an objective to provide a clear and easy to follow regime for data sharing and data reuse across the Union, and also to achieve interoperability both at the legal and the technical level. And I think that's a major step compared to the previous time, the previous directive, where it focuses a lot on how we can achieve interoperability, which I think was mentioned multiple times today, that is important to be able to actually make maximum use of any kinds of information. And finally, in case you have an issue with how the information is provided by a public sector body, to have a clear and simple redress mechanism in making sure you're going to actually find access to such data. Now, the overall objective is, of course, to develop a single European market for innovative applications on public data. And ever since the directive has come out, we have seen that this appears in multiple forms and guises in the different European Commission policy documents as to how exactly we can develop such a market, such a single market. Now, if we see how this regime works, we always need to bear in mind that we have essentially 4 layers of, let's say, legal items we want to, or legal regimes we need to take into consideration in order to be able to release the data or use the data. The public sector information rules, in a sense, they are the cherry on the cake. They're the icing on the cake. It means that you are able to actually release information if you're a public sector body, provided that you have tackled all the previous issues, that is copyright issues, data protection issues, and what we've called excluded subject matter. And this is expressed in the text of the directive. And it also means very simply that if you make sure you have this checklist of these 4 things, and we'll see it again later today, then you are able as a public sector body to release your information. So what it means to have such information, what it means public sector information. And I think we've gone through a long journey over the past 15 years when we started talking about documents, and from documents we gradually moved to data, and today we actually talk about any content, whatever the medium, or any part of that content in any possible form. So basically it means any kind of information or data under the sun which is actually is produced by a public sector body. And the public sector body rules, they are not necessarily crystal to everyone, but a public sector body, at least for the purposes of the directive and what we are talking about today, is an organization that either is governed by public law or essentially it serves a public mission. And I think that's all we need to know at this stage. And I think from member state to member state, we may have variations as to which these public sector bodies may be, and very practically you could see that if you need to have access to a certain type of information which is not readily available, you basically are going to apply, and because of this fairly simple redress mechanism, you're going to see whether it falls under the scope of the directive and the relevant obligations or not. So let's now get a bit deeper into each one of these layers of regulation. The first one is the public sector information regulations. And essentially they say that public sector information has to be made available for reuse. And that covers both commercial and non-commercial uses. So it means that information that the public sector body holds, it has to be made available, irrespectively of the licensing regime. Secondly, the licenses have to be standard and interoperable, which means the member states and the administration should try to minimize the complexity of the licenses. And we have seen a lot of work in this area over the past 5 years. Now governments tend to have as simple licenses as possible and as few licenses as possible. So ideally, I would say a good administration has a simple generic license that only requires attribution, or not even that. And then it has a license which allows sharing within a group, and then it has a standard commercial license. That's the simplest and idealist form of how you would actually release your data and your information. And finally, another innovation of this directive is that museums, libraries, and archives are now within the scope of the public sector information regime. That's a major breakthrough compared to previous version of the directive, and it means that there is much more information and content available to you in all under the conditions of the directive. Now, if we go a bit deeper, then we'll see that within a jurisdiction you may have sector-specific regimes. The most relevant ones are the INSPIRE regime, which is the geographical data directive, which has special rules as to how information is to be released, and statistical data regulations, which normally set some limitations as to what kinds of data they can be released or not. Normally, you are not allowed to release data up to the statistical unit of analysis if these data contain commercial or confidential information. So normally, PSI, what it does, it gives an umbrella, and what you need to know is that if it is geographical data or statistical data, just look a bit deeper if there is something else to ask about. Now, of course, to make sure that the public sector information is to be released, it has to be by a public sector body. It has to be owned by the public sector body. And this may sound as a bit strange. I mean, why would someone release something that they don't own? But it happens. So what you may need to make sure is that if you are a public sector body, that you actually release things for which you have obtained all rights. Just to make a very simple example, normally if you are a public sector body and you have, for instance, started a tender for reports, normally you will have the rights for the report, but not necessarily the rights for the underlying data. Or it could be that you ask for a map, a contractor builds a map for you, you have to make sure you have a license to share it with the whole of the world and not just use it internally. So this is what I mean, that copyright rules have to be applied before you actually go to the PSI rules. The other thing has to do with personal data, and from my experience, this seems to be the biggest issue. Normally, when we have a data set, if it contains personal data, the public sector body has to be legally allowed, legally able to release such data set. Again, there is a very simple way to actually obtain, make sure that you can release your data if you're a public sector body. You make sure that you have obtained consent from the data subject at the time of the collection of the data. For instance, I see also my Greek colleague down there. For instance, in Greece, because there is this rule that whatever expenses the state makes, they have to be automatically released on the internet through a specific service to be valid, legally valid. When someone is being paid by a public sector body, this employee actually signs also, there is a small paragraph that says, you know what, this set of details is going to be made available through the system. The other way to do it is, if you haven't obtained consent, is to try to anonymize it. And finally, there are cases when the legislators themselves, they have made a balancing between the right to know and the right to release information, and also the personal data protection rules. So there are times where you have explicit provisions that allow people to actually release their data. Finally, I'm going to the last part, which is the excluded subject matter. The excluded subject matter, it includes material that cannot be distributed. So normally these are trade secrets or confidential information. Make sure to remember this is going to be the exception, not the rule. And normally this kind of material is marked as such. So again, for a public sector body, it's quite easy to go through this whole list and figure out which is the information they are going to release and which not. Now, public sector information in the directive is like an aspirin. It helps you to get rid of the headache, which is how you're going to make this information available. But you need instructions. And it's always help to ask a doctor how to do it. And in our case, guess what? We are the doctors. So normally, if you want to have information, you need to know specifically about the data set or a service which is more difficult to be used. So you think there are issues. It always makes sense to ask a legal advisor from the relevant public sector body, or to get some legal advice yourself. Now, a few other items which are important. Data normally are not used as such. In a sense, they are not reused, they are not re-released. Data that we use for any kinds of machine translation or machine learning purposes, normally we take the data, we process them, and we provide a service. In that sense, in most of the cases that we've seen before, so if we go to this block here, you will see that we could actually go very easily to the PSI level, because information which is confidential is not going to be released, personal data are not going to be released. You just need to make sure you have the right to have access to it, and then you comply to the PSI rules to make sure that you can release the material in a kind of a uniform way. So, if we are to release the data using a PSI regime, basically we follow the stages that we have here. First of all, you check whether the material contains any confidential information or trade secrets, and if that information is there, you make sure they are not, you exclude it. The second thing is, in terms of personal data, you ensure you either have prior informed consent by the data subject, or you find a legal basis, or you anonymize it, or you make sure these parts that contain personal data are excluded. The third thing is to see if there are any third-party copyrights. So do we actually own this material, or this is material that were given to us only a very specific license? And finally, you follow the national PSI rules. So it could be that in different member states we have different ways as to how you release the information. In some countries you only need a notice to say that this is public sector information, and you may release the data immediately, and you don't need a license, and that is the case, for instance, in Greece. In other cases, what you have is you need to have a very specific license as to how it is released, as it is, for instance, the case in the United Kingdom or in France. And finally, if you are to use a license, use a standard license, a standard public license, especially for open releases of data. So I always recommend to people to use one of the Creative Commons licenses, or if there is a single national license, to make it as close to the Creative Commons licenses as possible. So let's try to see some cases from different member states. The first one is the case of this is the Clarity or Transparency project in Greece. It contains all administrative decisions. It's open by default. it uses a Creative Commons attribution license, but even if it wouldn't, it would still be, this data would be available for use by everyone. What is interesting here is that you can consume the data through an API, or you can download the individual decisions. And what is also important here is that very frequently the metadata are more valuable as a data source than the data themselves, because the data themselves tend to be PDFs, especially the older ones. Another example, again, I took the second example also from Greece. This is the example of the National Publishing House. It's like the National Journal of Information. You can find laws there. All of them are official publications. They're open by default and no license is required. They are consumed in both ways, both through an API, and people actually consume the actual information because all these material are machine readable. A third example is from the National Archives in the United Kingdom. They are made available through the relevant legislation, which are the PSI regulations. There you have model licenses. You have a single open license for all the material, the Open Government license, the OGL. And if you wish to actually release the material commercially, first you have to justify why you're releasing it commercially, in the sense of how much money you're going to make out of this, what's your sustainability plan, what's your data management plan, and then you have a model license and you pick bits and pieces and you form your own license in order to release it as a public sector body. The PSI exclusive agreements in the UK are quite interesting because they tend to be custom licenses. You cover all types of data, audiovisual data, textual, geodata. It could be, the reason why we have these kinds of approaches, some of them, they fall outside the public scope. So it means that these particular entities can commercially exploit the data. But you have to explain always, if you are to release it commercially, what is your funding, what's your financing model, and how you're going to make sure that there is a continuity and service level in the data stream you're providing. And I think these are very relevant questions to any public sector body that wishes to release data under a closed license. Then I have the Le Monde Diplomatique case from France. Again, we have transposition of the relevant law under the French law. Here we use ELRC licenses, and we have different types. The type of data here is newspaper archive, so they are mostly textual data. Here it's interesting, we have three types of licenses. We have one license which is for research purposes only. We have a second one which is for commercial uses, and we have something which is more closer to the freemium model. So you evaluate the data set, you see whether it's relevant to you. If you are willing to use it commercially, then you pay for it. So I think I'll stop here. I hope I made you a bit less perplexed than you were before I started. But if I haven't, we have a coffee break. All right? Thanks very much.
Yeah, actually from my side too, a big thank you for this explanation.
Did you get questions? Yes. Or?
Actually, yeah, if there is one question, we can do. No problem.
I was wondering how do regulations change if you're not actually publishing or distributing the source data, but derivative data? Like in the work that we do, we could be, for example, distributing statistics about words or neural activations inside a neural network. So there's a number of ways which you can cloud the original material, but still derive benefit that's useful for the community.
Thanks very much for. All right, yeah. Thanks very much. This is a very relevant question. Let me repeat the question to make it very, very clear. From the perspective of the reuser, what happens when the original data set is not revealed? Because normally the reuser is going to take the data set, is going to change it substantially and come up something which is either a service or something which is so different, which is very difficult to identify the source. Now, there are two issues here. The first one is how can you access the original data set? So your access to the original data set has to be legal. So it means that if it is confidential information or it is any kind of trade secret or commercial secret, you don't have access to it. So it's not legal unless you have a permission for that. Let me just, if it is personal data, any type of processing, you still need to have some kind of permission. If we talk about copyright, then in terms of copyright, then you may have, there is a kind of a leeway depending on how different the derivative from the original is, so that it's not even a derivative. And the final thing, of course, they have to be released under a PSI, a certain PSI regime. So if it's an open PSI regime, probably then you have no issue at all. You want to?
Yeah. Because you can do some of the processing, of course, inside the organization that has access to it, and then the distributor. For example, give you an example. Google, for example, has published language models that don't have any personal information anymore because they're only statistics, and similar things are being pursued by Microsoft and other organizations.
Again, I need to make this absolutely clear. At this stage, this is not just the problem of releasing, it's also the problem of accessing and processing. So accessing and processing, if you have any kind of license that allows you to process in the premises of the data provider or within a secure environment that the data provider agrees to, then you're fine. And then you have the second question, which is how you release them. But we have seen, and also we have seen in the context of the Clarin project or the MetaShare project, we have seen this question over and over again. Normally, we need to have a special license that allows you at least to do the processing in an environment which is acceptable by the data provider, and then we go to the second question, which is how you release the data, the final result. It may not even be data.
Yeah, Khalid Shukri, European Language Research Association. I think the issue is about the processing you're talking about, Alex. If everyone is using the same processing today, then it's fine. We're happy to get whatever you are ready to share with us. But we make this assumption, and Pro just showed Le Monde Diplomatique, that is data from almost 10 years back. If we have this data today, it's useful for today's technology. But what we would like to ensure is that it's sustainable. And no one knows what kind of processing we'll have in 10 years' time. And we don't want to come back and ask you for something new in 10 years. We'd like to have the raw data so everyone can process it the way they wish and with the tools they have. So this is the best option. But of course, if we can't get that, then whatever you're willing to share with us is welcome. And language models and grammars and whatever is a good piece of data.
But again, I think the work we have done in the context of Clarin is particularly relevant to this question in terms of licenses. I would add, you could also speak with Khalid or Tsiavos about the material we have produced. We have a whole booklet about how you could do this processing and some model licenses as well. Thank you.